Yeah, you can start.
Yes, sure.
A warm good evening to everyone. It's getting warmer, and I think the Supreme Court has served it quite hot, especially as far as the company law provisions are concerned. This was the judgment that everyone was expecting from the Supreme Court this year. You know, every year brings about a big judgment. 10 years back, in 2011, 2012, January, it was the Vodafone judgment of the Supreme Court. You had the Ram Janmabhoomi judgment, around 15, 18 months back. The Supreme Court pronounces these judgments, which not only have an impact on that case, but from time to time pronounces judgments which have an impact on jurisprudence, have impact on a law, and therefore on the constituents. And in this case, the constituents happens to be corporate India Inc., which pays almost more than 10 lakh crore in both direct and indirect taxes every year. Therefore, this judgment is huge, is critical, and it's not only important from a company law point of view, but specifically from operation mismanagement allegation point of view. That was at the heart of this case. Very clearly, the Supreme Court looked at this case as an operation mismanagement petition at the heart of it. And of course, that flew from the removal of Mr. Cyrus Mistry as director. It's a news that I remember. I broke that news on CNBC. It was October 23rd, I think, or 24th, 2016. And that news we broke at 6:15 live on national television, that this was a sacking. It was a press statement by Tata Sons that Mr. Mistry is no longer the executive chairman of Tata Sons. That innocuous press statement, and then one after the other, the salvos were fired. You had petition filed in NCLT, removal as director, of Mr. Mistry from several companies of Tata Group, followed by removal as director from Tata Sons. You had Tata Sons being converted from a public to a private company, and then we had an NCLT judgment, NCLAT judgment. Law, pardon?
By operation of law.
By operation of law,
Yeah.
absolutely, by operation of law. Then we had NCLAT overruling the NCLT on every score. You had NCLT clean judgment in favor of Tata Group, NCLAT reversing it completely, and then you had Supreme Court first staying the judgment. I still remember I was in the Supreme Court when the stay petition came up, and Mohan sir stood up along with Mr. Salve, Mr. Rohatgi, Mr. Singhvi, and we still remember the first words. The moment the matter was called out, the Chief Justice said stay before hearing any counsel. I think it was very clear. If one had to read the mind of the judges, you should have observed Chief Justice S.A. Bobde when the stay matter came up. When the matter came up for stay, exactly a year ago, within a year, the Supreme Court has completed the hearings, heard the matter, pronounced its verdict almost completely in favor of the Tata Group on issue after issue. And we have an ensemble panel who's going to decode this judgment, which will have huge ramifications on company law. You've not had so many judgments which really have left a lasting legacy. You've had Mir Mafatlal, you've had Escorts, and now you have Tata Mistry. I'm sure there are some more, quite a few of which Mohan sir himself would have argued, but these are the cases that come to mind. Mafatlal, Escorts, and now the Tata Mistry matter. Without any ado, I'll leave it to, I first ask Suhas, my great friend, managing partner of Legasis, and who on day one, when this battle broke out, what we are calling the boardroom battle, Suhas analyzed it as saying that the post of chairman is only for a meeting. It's not something a chairman is not by operation of law or any statute, whatever. It is only for a meeting. And so many points that Suhas discussed 4.5 years back on this case, so many of those points have now been ruled by the Supreme Court one way or the other. But if there are 5 or 6 points which are very important, which the Supreme Court has ruled upon, before I move to Suhas, one is on removal of director, 2 operation mismanagement, 3 on affirmative rights, 4 on certain clauses in the Articles of Association, like for example, Article 75 of the Articles of Association of Tata Sons, which pertain to forced sale of shares by any shareholder, proportional representation on a board, duties of directors. When such a big judgment comes, many a times we miss out on these smaller points. We look at the big conclusion, which is that Tata Group has won after such a fiercely contested battle. But we can miss out on these smaller points. These are the points that we will decode. The flow of today's webinar: first, Mohan sir's keynote. I'll first ask Suhas to give his opening comments. Then Mohan sir, one of the most eminent lawyers in the country, legal, constitutional scholar, former Solicitor General of India, and who also happens to be the counsel for Tata Trust in this matter, right from NCLT to the Supreme Court, and who strategized this case for Tata Group from day one. He himself will be delivering the keynote, his take. We have Mr. J.N. Gupta, founder, managing director, Stakeholders Empowerment Services, former executive director of SEBI, who will bring a corporate governance perspective to this entire matter. This was a corporate governance case on either side. Tata Group saying we've always stood for governance, the Mistry Group saying that the governance was shred to pieces. So he'll come in from a corporate governance point of view. I hand it over now to managing partner of Legasis, Suhas, a legal in his own right. Suhas, you are on mute.
Suhas, you are
Am I audible now?
Yes.
Okay. Thanks a lot, Arun. You are a good friend. That's why you always say good things about me. And thank you very much for that. You see, before we start off with this webinar, I just want to take a minute, or let's say 20 seconds, to actually pay homage and pray for Dr. K.C. Chakraborty, the ex-Deputy Governor of RBI. And we lost him recently, last week. It's a very sad story. The person who fought against criminalization of business was also, in a way, victim of criminalization of business. I mean, today, if you and me are not are out of the clutches of prepayment of home loans or prepayment penalties of home loan, I think it's largely attributable to Dr. K.C. Chakraborty. I request all of you to kind of join all of us in prayers for Dr. Chakraborty. It's very sad that we lost him. Having said this, I think I'm very quickly going to move right for every webinar that we've done. We've actually expressed our gratitude to the frontliners who have kept us very, very safe. These are law enforcement officers, healthcare workers, doctors, some of the artists who actually came out with the art during pandemic. A big thank you to everybody. I'm not going to read out these caveats in detail, but actually this is a webinar for general awareness. Don't consider this as legal opinion. We have a tremendous respect, and we will demonstrate that through our conduct for the Honorable Supreme Court of India and all those judges who have, honorable judges who have delivered this judgment. The webinar is based on the public domain information and what we had read in the orders. So if there is some information which is not available with us, and some of our conclusions might be wrong if we were privy to that information. And lastly, I think the views that we are going to express ourselves are personal views. They're not actually views representing our organization. Having said that, I'm going to kind of request Arun now to introduce Mohan sir and look at the general overview of the judgment and take it from there onwards. Arun,
Yeah.
over to you.
Yeah, I think we'll invite Mohan sir. To no audience on legal and tax does Mohan sir need an introduction. He's been in practice for over 37 years. He pursued the law both in India, overseas, and he's been invited to so many conferences where we've all heard him both in India and overseas. And during his time as Additional Solicitor General and Solicitor General between 2004 and 2014, he appeared on the other side. One of the youngest senior advocates in the country at the age of 41, if I'm not wrong. And very recently, he completed 20 years as a senior advocate wearing the senior gown, has appeared in so many cases on constitutional, corporate, tax matters, which have laid down jurisprudence. From the case of the two leaf symbol, election time, the two leaf symbol that the ADMK today has, the AIADMK, the ruling party in Tamil Nadu, that is thanks to Mohan sir then appearing for Ms. J. Jayalalitha in the Madras High Court. So you can't say that only constitutional law is his forte, or corporate law is his forte, or tax law is his forte. He can swap, he can bat on all pitches. He is not a batsman only for a flat pitch. Mohan sir always likes an analogy about cricket. So, sir, I'm sure this was a grassy pitch, sir. It must not have been easy to bat on this one.
Yeah, see, as far as the target was concerned, the NCLAT actually gave us on a platter. And therefore, the pitch was good, and we had good umpires, including the third umpire. And the team we selected was an excellent team. And we made a very good strategy of not letting too many counsel to argue. We decided amongst ourselves, we discussed, we had a team strategy. And in fact, I myself presented my written submissions. Singhvi also did not argue. Harish Salve presented the common submissions, but I gave independent submissions for the trust. Because Tata Trust stood on a different footing than Tata Sons Private Limited. And as far as this judgment is concerned, I would call it as a locus classicus. Because you just examine judgments of the Supreme Court, say 25 years back, 30 years back, and judgments which have actually been delivered, say 5 years back, 6 years, 8 years, etc. Even in tax jurisprudence, you will find, of course, they'll be quite knowledgeable, they would have laid down good law, but the clarity in which they are written, it all requires clarity and simplicity, and the way actually the Supreme Court has assimilated the complex facts in this case is something remarkable. And the way they have summed up the entire case in the 282-page judgment is something remarkable. And this, I think, could have only happened during the regime of judges like S.R. Das, Justice Gajendra Gatkar, and judges of those types. Even Vodafone is confusing. See, the way I think it was structured. And that is actually the first comment I would like to make about the judgment itself, the way it begins. And any student who goes through the judgment will clearly know the structure of the Tata Group, because they explain the entire history. And also they will also know the important principles of corporate law, primarily concerning the question of oppression and mismanagement, how the law is developed in England and India, and what is the current position, what are the principles on which you can say a particular conduct is oppressive or amounts to mismanagement, or is prejudicial. And secondly, the court has also examined many other principles of corporate law, including the importance of independence of directors, the primacy of the articles of association, and how a company is to be run, corporate governance, corporate democracy. And it has also made some subtle comments against Mr. Mistry at many places. In fact, at one place, when it deals with Mr. Dwarakadas's argument, he represented Mr. Mistry. It calls Mr. Mistry, Cyrus, as the original composer of the music ensemble. So, see, the judgment also contains some satirical comments, you know. And it has examined the approach, see how it has proceeded with. It has first actually examined the entire factual background and it has clearly understood what really happened in the beginning. Initially, Mr. Cyrus Mistry was only replaced as executive chairman. That was not a loss of office, mere replacement. And he was given an option to continue as a non-executive director. The choice was his. And he invited trouble by actually making press statements and leaking information to the directors, resulting in the calling of the EGM. And therefore, he was sought to be removed as a director. Those facts have also been brought there. They actually say that he invited trouble for himself. As far as removal of directorship is concerned, it deals with the situation as to how things became complex, how pleadings were sought to be amended, what was the original plea that was actually filed in the company petitions by these two proxy companies, front companies, and how they were sought to be amended later, some in the form of a formal application, some through affidavits. They have actually sought to even put a tabular column in the judgment very clearly so that everybody can understand what transpired before the NCLT. And they also adverted to the fact that by that time, I think everything had become infructuous because NCLT did not pass any orders. It was all made subject to. And the application was held to be not maintainable initially before the NCLT because he did not have the threshold limit of maintaining the petition. It went before the NCLAT, again came back to the NCLT, and NCLT proceeded to re-examine the matter. And then the Supreme Court examines each and every allegation examined by the NCLT. Allegations pertaining to oppression and mismanagement, which starts from paragraph 3.2. He actually makes a casual statement that Tata Sons Private Limited is a proprietary concern of Mr. R&T. And there has been clear-cut misuse of several articles, including articles 121, 121A, 86, 104B, and article 118. And more interestingly, if you see, they have actually gone into the issue of the scope and purport of Article 118. In fact, at the time of his being replaced as executive chairman, I had offered an opinion that for replacement of executive chairman, one need not constitute a selection committee. That second part of 118 will not apply. The opinion which I gave was concurred by two eminent judges, retired judges of the Honorable Supreme Court. I don't want to name them, but a former Chief Justice of India dissented. But the NCLAT said that what is stupid? It says same procedure. So you should have constituted a selection committee to remove him. Supreme Court says that it will be nonsensical to constitute a selection committee for removal. So they also go and examine the scope and purport of an article of association, and also on the question of interference, and also take into account the facts of the case, and examine the scope of each article in the factual setup also, and come to the conclusion that there was complete corporate governance, and they actually turn Mistry's case against Mistry himself. Mistry was heavily arguing that the committee had certified in June that he actually had been one of the best persons, or the best chief executive who had actually carried the affairs of Tata Sons in the most efficient manner. So the bench says, if that be so, that actually is in clear-cut conflict with the allegations of oppression and mismanagement. How can both coexist? No? So then they actually go into and examine all the allegations of oppression and mismanagement considered by the NCLT. NCLT considers everything. I do not want to now actually discuss each and everything here in this webinar. But whatever was discussed by the NCLT was threadbare discussed once again by the Supreme Court, which actually the NCLT completely miserably failed to even examine. And that was actually severely criticized by the Supreme Court. The approach of the NCLAT. And in fact, the Supreme Court clearly seeks to make a analysis between the approaches of the NCLT and the NCLAT as the final court of appeal, that is as a tribunal on facts, and also deals with the various contentions, and it actually only correctly posed 4 questions of law which arose for consideration before the Supreme Court. In the present matter, I would call this judgment as, I think, very remarkable. I think post-barium chemicals, I think post-escorts, post-needle industries, Junjunwala, I think this judgment, I think, is a very high watermark. And you have seen succinctly they put 4 questions. And for the sake of the benefit of the participants, this is the crux of the matter. They did not want to actually frame 50 questions. No? And first issue was whether the formation of opinion by the appellate tribunal that the company's affairs have been or are being conducted in a manner prejudicial and oppressive to some members, and that the facts justify the winding up of the company on just and equitable ground is in tune with the well-settled parameters and especially in the light of the fact and findings of the NCLT on facts were not individually and specially overturned by the appellate tribunal. The answer is also found in the question itself. No? And the second question was whether the reliefs granted and the directions issued by the appellate tribunal, including the reinstatement of Cyrus into the board of Tata Sons and other Tata companies, are in consonance with the pleadings made, the reliefs sought, and the powers available under subsection 2 of section 242. Number 3, whether the appellate tribunal could have in law muted the power of the company under Article 75. That is actually the power of the company to compulsorily purchase shares, which is in existence even long prior to these guys becoming shareholders in the company. And the fourth issue was whether the characterization by the tribunal of affirmative voting rights under Article 121 to the directors nominated by the trust in terms of Article 104B is oppressive and prejudicial, is justified, especially after the challenge to these articles have been given up expressly. Again, the answer is found in the question itself. Then whether the reconversion of Tata Sons from a public company into a private company requires the necessary approval under section 14. This also we saw, it was by sheer operation of law. And here they also discuss needle industries. Needle industries, actually, they say there are 3 types of companies: a public company, a private company, and a hybrid company. This remained as a hybrid company, and that hybrid character automatically changed by operation of law by coming into force of the 2013 Act. Therefore, this doesn't require a fresh application under section 14 of the 2013 Act. And that way, I think this judgment is a path-breaking judgment, and there is absolutely no scope of any confusion in the judgment. It has set the house in order, and it is good for Indian corporate democracy. Also good for, I think, future guidance for several cases which may arise in future, because there was always some confusion with regard to the scope of section 241, 242. And there I think this court has thrown a lot of clarity into the scope of 241 and 242. And also the court has clearly actually explained what do you mean by a quasi-partnership, and has examined old cases as well, and has done a great amount of service by examining important case laws. I think with this, I throw open the discussion. Thank you.
Yeah, thanks, Mohan sir. Thanks so much. Suhas sir, if you want to just throw one question at Mohan sir, just one.
Not really. I think who am I to question him? I think it's
Yeah,
like
fine.
he's kind of argued the matter.
Yeah,
Sir,
perfect.
one question, if I were to kind of push to ask, I would say all throughout this judgment, one comes to the conclusion that there is of course, as you rightly said, there is a clarity which comes out. But just short of finally concluding, there does seem to be some withholding of the pen, if I were to put it that way. Because on many occasions, on many places throughout the judgment, I think the court seems to be going up to the final point, but not crossing the finishing line. That's my perception. I may be wrong.
Possibly the court wanted to maintain some decorum in a matter like this. It has certainly made some comments which itself, normally the courts don't make, no?
That's true.
Therefore, I think they refrain,
That's true.
being the highest court.
That's true. I agree with you, sir. Thank you very much. Thanks for that articulation.
Thanks so much, Mohan sir, for joining in and presenting your insights on this landmark judgment, and congratulations once again, sir. I mean, that was Mr. Parasaran, legal constitutional scholar, former Solicitor General of India, and also who led the charge for the Tata Group, right from strategizing this entire matter to right up till Supreme Court. We've not heard the final word on some issues where the Supreme Court has kept quiet, like the valuation part, but that is for another day. Thank you so much, Mohan sir, for joining. Thank you so much.
Thank you very much, sir. Thanks a lot.
Valuation part, I do not want to speak because there are so many issues which are cropping up, and that I think I'll have to keep my professional confidence. No?
Sure, sir.
Thanks so much, sir. Thank you.
Sure, sir. We completely understand that. And I think we also would like to just kind of look at some of the indications which are there within the judgment itself, but not really go there. We would want to analyze the judgment. Please feel free to guide us through the webinar, whatever time that you have. Sir,
sure.
Because what I'm going to do is I'm going to quickly run through a PPT and then come back to Gupta sir for some of the critical analysis. And through this, I think I'm going to request Arun whenever possible. I think we will have a dialogue and we will kind of iterate this. Very clearly, some overview, some nuggets about the judgment, 282 pages, as Mohan sir said, the 21 paras, 5 core legal issues seem to be addressed as legal questions answered very clearly. This is a unique style of writing judgment. We haven't seen, and Mohan sir alluded to that, we haven't seen these kind of judgments in order coming out of the Honorable Supreme Court for a while now. It's laced with humor at times. It has Elizabethan English phrases in there. There are some Sanskrit words and phrases, and it's an interesting read for any student of law. What is also heartening for student of law and junior lawyers like us is that the entire adjudication got over in 4.5 years. Started off from removal from the chairmanship somewhere in October 2016. And we kind of got that right. We said chairman is chairman for the meeting. There is no statutory kind of authority there. And the final judgment and order we have is March 21. So while the world will talk about the dilatory justice delivery system in India, completely delayed and flawed, that might be true in some cases. But here is a startling example where I think in 4.5 years, you have a final judgment from the Supreme Court. Having gone back and forth on attritions between NCLT and NCLAT, again, this is attained finality with respect to many of the legal issues for the first time being talked about under the Companies Act. And as Mohan sir said, of course, the minority operation and mismanagement related issues, very clearly, there are some finality of law that has been attained. Also for me, I think, and for every lawyer, you see, when we looked at NCLAT, we always went by the nomenclature. We said it's an appellate tribunal. And we said an appellate tribunal is an appellate tribunal. It can correct the facts of the lower tribunal. It can correct the facts with respect to NCLT. But this ruling now establishes that NCLAT is final court of facts. And what this really means, a final court, I'm sorry, I've used plural there, but that could apply to other tribunals. Having said that, I think what this really means is that when it comes to factual determination, I don't think Supreme Court will rewrite what the facts that would come out from NCLT and NCLAT. A couple of takeaways, other takeaways is that, we've seen from 2018 to 2020, when it came to protection of minority investors, and that's where I think we will come back to Mr. Gupta, is that on ease of doing business, the India's ranking has slipped from 2020 to from 2018 to 2020, from 13th position to 7th position. From 7th to 13th position. It was 7th in the order of preference. It went down to 13th. One of the important aspects through this judgment that's coming out is that affirmative vote atoms, which actually give sanctity to the investor protection, whether that investor is a minority shareholder or otherwise, I think that can be culled out from judgment. And probably one of the experts who I talked to said that this affirmative vote atom gaining sanctity through this judgment will actually improve India's position on ease of doing business. Of course, we have reestablished the fundamentals of corporate democracy through this judgment. There is a fantasizing of corporate governance deprecated. And Gupta Sahib, I'm going to come back to you on that issue subsequently. Having said that, some of the other nuggets that we will look at is that there is a recognition of the fact that the colonial vintage still kind of haunts us, and that's the English law, and that kind of continues. Therefore, there is a great emphasis on analyzing the difference between the English law and Indian law, predominantly when it comes to what is prejudicial to the interest and how that has dovetailed into operation and mismanagement. I think there is a great deal of discussion around it. Quasi-partnership on every matter that we went to the earlier avatar of NCLT on operation and mismanagement, the CLB, and now NCLT, almost on every matter, the minority shareholder came out with this argument about quasi-partnership, which was evolved through common law principles in a very popular sense. But I think a quasi-partnership could have been at the formation of the company. In this case, it was not even at the formation of the company. It was somewhere in the middle of the journey of Tata Sons. But it says what you may have done in earlier avatar, and it uses the word Purvashram. In Purvashram, you may have been partners, but that doesn't mean that you will continue to be partners. And therefore, this concept of quasi-partnership in minority operation and mismanagement issues is kind of giving a different credence. Probably not on every matter one can now argue about quasi-partnership, or every company being quasi-partnership, where the minorities will come back and kind of claim that they were partners and therefore they needed equal rights in the management of the company. The objective of the litigation has been deciphered, and I think at one place, very interesting Shakespeare and Hamlet phrase being used to say that the objective of this litigation seems to set things right in the state of Denmark. I mean, all of us know what that is, and that's a very interesting phrase being used. When it comes to relief of reinstatement, I think a phrase used in the judgment is the relief of reinstatement was too big a pill, even for the complainant companies to swallow, or perhaps Mr. Mistry to swallow. A very interesting phrase again there, because NCLAT probably went overboard and actually granted reinstatement even after the term was over. Anything you want to add, Arun, Gupta sir?
Not at all. In fact, Suhas, just one point, and which is that, and I thought we'll come one by one to some of these issues, but the fact that right at the very outset, the Supreme Court said that the NCLAT did not consider several issues of facts which were not dealt with by the NCLT. The NCLAT did not get into them. For example, some of the allegations pertaining to AirAsia, Sivaraman, Tata Motors, Nano, so on.
We'll come back to that. We'll come back to that.
I thought some of those, as far as the writing style is concerned, this is one of the unique judgments. I've read a lot of Supreme Court judgments. I am not able to fit it into any it doesn't remind me of some other judgment. So this is quite a unique writing style, I must say.
Thank you, Arun. Gupta sir, some opening remarks and.
Okay. Thank you very much, Suhas, for giving me an opportunity to be here. And I heard Mr. Parasran, and he had made most of the points which a normal person would be making. But he spoke about one sentence where he said Mr. Dwarkadas thing, and the court has observed that he is the orchestra of the music, or he is the starting of the music. Similarly, on page 270, they have a remark about NCLAT. He said that NCLAT was surprised, and the bracket the judge writes, quite surprisingly. So that is where it says, and that answers the thing which Mr. Parasan said, that court stopped giving the final judgment because they wanted to maintain decorum. They do not want to publicly flog somebody that. Having said that, I have a very disturbing observation which is coming to this, that you look at in India, as it is, our legal system is a very long, prolonged legal system, and justice gets delayed, and you said it is in 4.5 years. But if you see, there is a pattern. One court decides something which is black, other courts caught the same thing as white, and then comes to the Supreme Court to decide whether black is black or white is white. And this has happened in this. NCLT gave a judgment, NCLT went to the other pole, and then the Supreme Court had to come. Now that brings us to the issue that should there be some sort of a accountability of this, that when judges write the orders, they have to get rid of their personal liking, disliking or something, because it is impossible for me that an educated person can interpret things in totally different way. And I will bring it another thing, that presently what is happening in Delhi High Court in Amazon versus Future and Reliance, one set of judge gives order which is black, other set of the judge which gives order white, and I don't know how this is being allowed, because things gets on a litigation. One day there is a stay, other day there is a stay is vacated. So I don't know how the judicial system is coming. Now coming back to the episode, the problem is that we become emotional, and when we become emotional, we start siding with people. Now the first thing was this, that they're playing a victim card, that I am a 18% shareholder, I am being victimized. Now, nobody saw what is the issue at the core. I have been maintaining right from day one that Mr. Mistry was not executive chairman of Tata Sons because he was a shareholder. He was picked from some place by the search committee, and he happened, it was a coincidence that he was a shareholder also. His shareholding was neither a precondition nor was considered for appointing him as a chairman. Then Mr. Parasran has, and the Supreme Court has already brought so many things into judge, that his removal was only as an executive chairperson, not as a director. And if anybody who has recalled what I spoke on the very first day, I said when the news came that this action is amounting to something which is an earth-shaking event. Now, we still do not know what was the earth-shaking event, which did not allow Tata Sons to wait for 3-4 months. But the subsequent conduct of Mr. Mistry, if you connect 2 and 2, and then you know that there was something really wrong that was happening. Then the issue is this, that we interpret the law, or we interpret the writing into article something in a very literal sense, which is not. And Mr. Parasan has said about the search committee for removal being a something which is nonsense which Supreme Court has observed. But logic says when you have a search committee, you are selecting one from many. But when you are removing one person, there is no question of one from one. So there is no choice. So there can't be any committee for that. Then comes to the governance. I think we have a very wrong notion of what is the governance and what is the meaning of governance. We tend to see that the governance is protection of minority shareholder. That is a very, very small portion of governance. The first and foremost important thing is protection of the company, its value, and increasing its value, and taking into account all stakeholders. That is governance. And governance is not law alone. Governance is much beyond that. Yes, Suhas.
Sir, that's completely, everybody is in agreement with you. And I think this judgment actually throws a far clearer light on this aspect that you're talking about, which is what is corporate governance, and it actually traverses beyond, the nominator's interest, so to speak. And I think from that perspective, we'll definitely kind of look at analyzing this judgment as well. Thank you, sir.
Yeah. Suhas, just one comment on that note, taking off from where Mohan sir and especially Mr. Gupta just mentioned, and I think brilliant points by Gupta ji. So succinct and a lot of takeaways from Gupta ji, and I couldn't disagree with either of them. But one point I thought as a context which summarizes this whole case in that Supreme Court judgment is they said that how could NCLAT find it just and equitable to say that how could the NCLAT find it reasonable? Or how could they in any good conscience say that it is just and equitable to wind up Tata Sons and starve to death Tata Trust, which is doing yeoman charitable work? I think somewhere the group structure, what the group stood for, its values, the way it's been governed for the last 100 years, though Gupta ji says that these are factors which possibly are on the sidelines and one should not have emotions, but in a case like this, to say that judgment can be rendered dehors history, dehors emotions is also a little, I'm not saying Supreme Court has not gone into the facts, but I think some of these points have played a big part. I think somewhere the Supreme Court also has thought, can you hold it just and equitable for Tata Sons to be wound up?
No, I completely agree with you, Arun. But coming back to this issue about corporate democracy and corporate governance, see, let's understand, and I'm trying to briefly kind of look at what was the argument, and it was a very novel argument in that sense. Okay, the argument was, they said under the Companies Act 2013 now, this issue about corporate majority or corporate democracy has moved on to give place to corporate governance. And that corporate governance per se includes the principles of fairness. A very innovative argument, a very novel, as well as it's an argument at the first blush. Somebody would say, yes, it merits an attention. However, I think deciphering this, Supreme Court has said that it is good to wish, and I'm going to kind of read this out because it can't be expressed any other way. It is good to wish that the creation gets liberated from the creator, so long as the creator does not have any control or ability to manipulate. In the corporate world, and I think this is very important in today's context, democracy cannot be seen as an ugly expression. After using the same democratic process for appointment of directors. Now, this is where the meaning of and this conflict about minority shareholders protection, the majority, corporate majority, or corporate democracy giving way to the corporate governance has been dealt with. And I must say that this is one celebrous learning as a student of law today, that whenever there is an issue about corporate governance, I think what Mr. Gupta ji said is absolutely right. It's not about interest of majority or minority. It's also dovetailing together on the corporate democracy principles. And therefore, what Supreme Court did on this issue is, while NCLT ruling, which was like very clearly saying that Companies Act 2013, it's like corporate democracy is the genesis of this enactment, and corporate governance is the species coming out of it. They're never in conflict with each other. Accountability to the shareholders in the present regime, again, corporate governance is collective responsibility and not based on assumed freehand rule, which is alien to the concept of collective responsibility endowed upon the board. We had all the four fundamental fiduciary duties of the board of directors coming from hundreds of years together. But while upholding what NCLT did, I'm not getting into what NCLT did on this issue because it's very difficult to decipher it. What Supreme Court did was very interesting. Supreme Court said that provisions of this sections 135, 49, 50, and 66, 77, around which the argument relating to corporate governance, it appears to be fantasized and it cannot advance the case of Shapoorji Pallonji Group. A very, very interesting argument, because this fantasizing of corporate governance, and I think we all who have kind of looked at fundamentally what the governance norm should be, what corporate governance means, and it needs to go beyond merely the letter of law. I think welcome this judgment. Corporate governance is not about fantasizing the concepts. It's about what is the core issue there. Again, very quickly, I think the judgment deals about just and equitable ground for winding up. And I think one of the critical in a series of cases right from beginning on minority shareholders operation and mismanagement has been this issue about the misconception on whether there are grounds enough to wind up the company had such action been not there. And I think that goes to the crux of the matter with respect to operation and mismanagement. Because I think we have experienced that whenever there is this minority operation and mismanagement issue, I think there is always this tussle about what is right and what is wrong. Many a times the corporate decision making is subjective in its nature. At that point in time, what somebody may view as a wrong doing or a decision which is not, forget about the defensibility of the decision, but which is not in the interest of the company per se, not in the interest or it is prejudicial to the interest of the company. In that sense, therefore, a minority action comes up. But whether that can result into such a prejudice, which kind of otherwise qualifies the company to be wound up, is being a very important element there under 241. And this is one of the criteria. And I think there is discussion around this. The second larger takeaway for us is, you see, the affirmative vote atoms that we've been used to, whether it is private equity, whether it is any of the investment agreements, we've had this issue about investors trying to say that some of the votes that are to be taken at the board level and some of the votes that are to be taken at the shareholders level or in the general meeting, they need to have the affirmative vote from those investors. I think it's a larger issue which would go beyond merely the Tata Mistry case, is actually this issue about affirmative vote items. And that it's been completely legitimized and legalized to say that there is nothing wrong in having this. There's nothing wrong in making sure that you have, through affirmative vote, ability to control whether it is supermajority at the board level or whether it is kind of a Russian roulette that will happen. But at the same time, what the court seems to be suggesting is that look at whether such atoms are in the larger interest and they're not prejudicial to the interest of the company. Of course, the second legal point that has been kind of addressed very squarely is the reliefs going beyond prayers. And that's where I think Mohan sir alluded to by saying that we were given a very good pitch by NCLAT. NCLAT actually probably went overboard in saying that even beyond the original term of the directorship, he needs to be reinstated and he needs to be kind of, I mean, there's no way in which, whether you talk about specific relief act, unamended or amended, and that's come out very clearly in the judgment, that these prayers could have been granted. Or let's say they were not even prayers, but the reliefs granted beyond prayers. Of course, there is a discussion about reconversion from public to private by operation of law, as Mohan sir said. But sir, I beg to differ with you, and we'll probably have a discussion about this hybrid company concept, which is kind of a bit tricky there. And I honestly, under the Companies Act 2013, there are no hybrid companies any longer. Either you are private or you're public. So, but that's a separate discussion. We can do that later on. Very quickly, I'm saying some of the kind of nuggets, again, I'm trying to pick through this, is that they have interpreted the law to mean that you can't actually look at distance past. You know, it's really events which occurred 10 years ago. Can you really assail them today? They're also saying that an apprehension, when it comes to Article 75 and its misuse, the Honorable Court seems to be suggesting that you can't base your action, especially of operation and mismanagement, a minority operation and mismanagement, based on a future apprehension that something wrong will happen. So actually, one of the learnings for me is that, don't go back in distance past. Don't look at the issues 10 years ago. Of course, here the additional complication was that Mr. Mistry was a director, was there within the system during the period of those 10 years. But minus that, also going back 10 years in terms of valuing and these pleadings coming to conclusion, therefore there is a trend of operation to the minority, I think has been deprecated. Very interestingly, I think the future tense is also ruled out today when it comes to misuse of Article 75, and I think the ratio is quite clear. The interference, whether it warrants an interference based on the future event, I think also a distant past. So therefore, in my view, sir, with due respect, I think the kind of and read the judgment, all of us read the judgment, is the present continuous tense that's kind of forced upon, and looked at it in that sense in a verbatim manner and interpreted it accordingly. Again, what is a conduct which is prejudicial, and prejudicial to who? I think is also kind of today articulated, and this is a very clear ruling here, which says that under 2013 Act, conduct prejudicial to the any member or prejudicial to the public interest or the interest of the company are all added onto the elements of operation of the minority. And I think from that perspective, one of the critical areas, together with just an equitable ground for winding up, is this issue about whether the acts are actually prejudicial, and prejudicial to who. A completely welcome clarity here. Secondly, there is a huge discussion about this issue, which is an enabler under the legal provision, which was there in 56 Act, which has been there, that the courts have powers, and earlier it was Company Law Board, prior to that it was High Courts. I think the courts and the tribunals have power to pass any orders to end the matters complained of. And I think to bring an end on a just and equitable ground, the courts have power. This has been interpreted by the Supreme Court in a very clear manner to say that it is in aid and abeyance of the existing powers which are specified, and it has to be in consonance with those powers which have been enumerated. I think I'm sorry. The failed business decisions, and this is where I think the business decisions at the board level, including those where the independent directors participated, will come to the forefront. You see, the failed business decision and removal of a person from directorship can never be projected as acts oppressive or prejudicial to the interest of minority. And I think this is, sir, very it's been clearly articulated. Therefore, there are going to be decisions at the board level. Some of the decisions will fail. You will have to really look at it from the test of whether that is prejudicial to the conduct, to the interest of the company, whether it could be prejudicial to the interest of the company, whether it is prejudicial to any member, whether it is prejudicial to the public interest, or whether it is prejudicial to the interest of that particular minority that claims to have been oppressed. So I think it's again bringing out a very clear proposition and articulating it in a manner in which the decision making can never be hampered. We have seen at the boards, or whenever there is this dispute about minority and majority, and sometimes these disputes can go on for years together. I think the issue at that crux is that when the directors start deciding at the board level, they always look at saying, will my decision be challenged by this warring minority? And I think this clarity here will go a long way in ease of doing business and the confidence of decision making at the board level. Okay, on the quasi partnership, probably this is an end of era of quasi partnership here, as I stated earlier. What is a quasi partnership was always a complete factual and legal question entangled together. Most of the times, the partnerships get converted to limited companies, joint stock companies. Many times, it's two partners or two promoters coming together, three promoters coming together, subscribing to the memorandum as promoters and form a company. They decide probably at the beginning that they would have joint responsibilities and they will share the powers and authorities. But down the line somewhere, things change, and they're bound to change because I think the corporate as an entity is always dynamic. So from that perspective, I think probably there's an end of era of this quasi-partnership argument, except there are some gateways which have been kept open here, which is still all right, and we can understand that. There's a very interesting line, and I think it's a very funny line there. Again, as I said, this judgment all through uses humor succinctly. Today, nobody wants to step down from any office except if afflicted by brain stroke or stun stroke. A fun there, but what is intended to mean is that nobody will step down on his own. Again, what very interestingly, the court suggests that you have CPC and Evidence Act, and you have rigors of CPC and Evidence Act when it comes to the procedures and pleadings in the court of law. The court seems to suggest that, yes, the tribunals have evolved this process subsequently, but the manner in which people kind of go on amending pleadings and go on, bending the procedure a bit here and there to see or to kind of look at new elements that will come up. It's at that point in time that when you look at the entire matter with the benefit of hindsight, when you're looking at this matter after 4.5 years, I think you really need to decipher what all has happened, who has given concession to what, how the pleadings which are subsequently filed affect the original pleadings. And therefore, the court seems to have remarked this with respect to tribunals and quasi-judicial authority, that while the procedure and the rigors of CPC and Evidence Act will not apply, because fundamentally they thought that this would delay the entire proceeding. But the court seems to have come down a bit sarcastically there to say that instead of eliminating the delay, this has eliminated discipline in the pleadings and procedures. And I think this will again, for junior lawyers like us, will actually help us in deciphering this correctly. Very interesting again, the object cannot provide a remedy worse than a disease, the object of the litigation, the object of the law. The object should be to put an end to the matters complained of and not to put an end to the company itself, forsaking the interest of other stakeholders. It is relevant to point out that once upon a time, the provisions of relief against operations and mismanagement were construed as weapons in the armory of shareholders, which when brandished in terrorem were more potent than when they were actually used to strike with. And that was the regime. I think India would move beyond that regime now and look at the issues on operations and mismanagement in a very, very different form, and not really a weapon with terrorism there. Of course, reinstatement of the director has been talked about. Unless there is a viability at the beginning, they've said there is no way that the director who is removed could be uh, reinstated. You see, so some of the key takeaways, I mean, I'm going to briefly touch upon it before we move on to various other questions and answers or the dialogue around it, is to say that directorship, unless it is prejudicial, not a cause of operation and mismanagement. That's quite clear takeaway for me. Granting reinstatement after tenure is over, I think that is the principle of legality there, again and again rubbed into, notwithstanding specific relief act. Reinstatement of a director, I think it will be very, very difficult now on the facts and the merits of each case to prove that the director should be reinstated. Invocation and just and equitable grounds for winding up, I think will have a very clear meaning, and it's a great takeaway. Again, I'm saying future bad conduct and likely misuse are not permissible within 241, 242 for operation and mismanagement comes out very clearly. Quasi-partnership has a very limited role in operation of law. Corporate democracy and affirmative vote atoms, I think dovetail in correctly, and clear meaning on corporate governance under Companies Act 2013. I thought these were some of the clear takeaways insofar as I'm concerned. Arun, you want to talk on any of these? Should we be kind of discussing?
No, I think there are quite a few questions which we can take. But Suhas, there is one point which I did want to bring up, and I thought it is interesting that they've also the Supreme Court has gone in quite deep into what's the scope of Article 241, Section 241, 242 pertaining to operation mismanagement, and when you say that the tribunal can pass an order as it deems fit, what does it mean? I think they've read it down. That's one part. Everything else falls within a context with some particular fact pattern, how the Supreme Court has viewed those fact pattern. But Suhas, this point on the scope of 241, 242 itself, they've said that deems fit doesn't mean that you can pass any relief you wish. I think they've defined the contours here. I think they've read down this, Suhas. I don't know what's your take.
No, see, Arun, see, there are two issues which kind of are. That's where I'm saying that the judgment goes up to a point but doesn't cross the finishing line. Okay, it goes on to say that you will have to interpret this any other powers which are equitable reliefs on just an equitable ground, and it says it has to be read in conjuncture, ejus remedium, to the prior provisions that have been mentioned there as the powers and authorities, and it has to be in consonance with that. That's perfectly valid insofar as interpretation is concerned. But on a given case, whether that would limit the powers of NCLT and NCLAT, I think we'll have to look at what the case would be. Because again, now this will go in a very different manner, because I think the powers are wide enough. I think the wide powers which are specifically there under 241 and 242, I don't think can be read down by the interpretation of this any other relief on the just and equitable ground. It will have to be read in together with this. I don't think they will be reading down of it.
The duties of director, I found it quite interesting. I'm not dealing with all the questions now, Suhas. Even 4 hours will not be enough. But duties of director, where they go on to say that a director who's nominated by an institution, he has a duty towards the company on which he board is. He has a duty towards the institution which has nominated. It's a fine balancing act. We recognize it. And they've gone on to say that profit is not an ugly word also, just as they've said that majority is not an ugly expression of democracy or whatever. Similarly, profit is not ugly as well. And therefore, I think the Supreme Court has tried to do the balancing act at many places, not saying that, okay, a director nominated by an institution is only beholden to the institution which nominates him, but at the same time, we can't deny the fact that he has to protect the interest of that institution as well. And therefore, if he goes and consults them before taking a position, that doesn't mean that someone becomes the shadow director, someone is remote controlling the affairs, and so on and so forth. So the balancing act, the fiduciary duty of directors, oh, these are things that, Suhas, we've been talking ever since I've started. My first year in journalism in 2004 at CNBC. We still are talking the same thing: duties of a director.
And that too, the four fiduciary duties. That's the core fundamental. But Arun, I think you see there are. I mean, does this give a totally different meaning today? I think it just kind of tries to decipher the bad elements in corporate India today, which is we have seen that under the garb of a minority action, I think the litigations go on and on in a very, very protracted manner. And I think this is one area where I think there will be a lot of learning for all of us as students of law to say that you can't use dilatory tactics any longer to prolong a litigation scenario. You see, because on the threshold, you will have to really make out a good case to be qualified for operation and mismanagement. And I think if this, although, personally, I feel there were various opportunities that could have actually lent credence to this judgment and it could have gone up to the finishing line. But that's my personal view and take again. I'm saying LIC versus Escort needed a probable reassessment at this point in time. We needed reassessment from NIDL also. There is a discussion about NIDL, but it again, discusses, doesn't go beyond that. So I'm quite, quite intrigued by the fact that while it traverses up to the finishing line, it doesn't cross the finishing line.
Plus, we have a couple of interesting questions. The first one is, what is Ankit Mishra?
See, Arun, before we do that, I wanted to request Mr. Gupta ji for his views, and before we take the Q&A, sir, anything that you would want to add.
But Suhas, I think this question Gupta ji will surely answer. It's
Sure.
He's the right person for this. Ankit asks you, sir. So, what is your opinion about the significant minority argument taken by the SP group? The significant minority.
See, Arun, thank you. I would say that we have a habit of picking up some fancy words to make out a case. Now, in corporate India or in the analyst think that minority protection, minority operation, mismanagement, prejudice are the few words, if you put it in a sentence, it reads a very good reading. So I would say that first we have to define what is wrong, where something is getting hurt. And as I said, very simply, there was an argument that 10 years back, Chorus was taken over or Jaguar was taken over. I remember when Chorus was taken over, the entire country was gaga that India has been put into the global steel map. Everybody was so appreciative of Tata taking over Chorus. Then similarly, when Jaguar was taken over, everybody criticized. And 10 years down the line, it took other way around. Jaguar was the money spinner, Chorus was a millstone round the neck. And if you analyze all the decisions 10 years late, then I think that I am more intelligent than Einstein, because I can also give a theory of relativity today or theory of gravity. The issue is that you got to analyze what happens at that particular time. And the second thing is this: if you have been sleeping for 10 years, enjoying the fruits or pain of my decision, 11th year you can't say that, look, you were prejudicing me or you were oppressing me. Then oppression has to be a deliberate, it has to be painful, and it has to be regular. It can't happen that you slapped me today it means that it is a continuous operation. You got to be slapping me every day so that I can make out a case of operation. Then the question comes, how can a thing be good for a minority if it is not good for majority? I don't know how to run a company where it is good for 5% of the majority, but it is for 95% of the majority, it is bad. What happens? It is only a case of operation when the majority shareholder in person is taking benefit out of the company for his own benefit, which in this case is absolutely absent because there is no person behind it. And whatever is the person behind it is a trust, it is a charity. So you can't say that a charity has benefit out of my money. That is just something like this. So I would say that operation has to be used very judiciously, and it cannot be just one instance. And secondly, if the company has made a loss, how it is oppressive to the minority? 82% of the other shareholder have also shared that loss. And it would have been a problem if that money would have gone to the personal pocket of Mr. Tata or some executive or something else, then it would have been operation. And then, as Mr. Parasran said, the Supreme Court has very cleverly said that if you have entered through that gate and you are criticizing that, you have been at the helm of affairs for so long and you were hunky-dory everything, then suddenly when you are removed, your eyesight has improved, your intelligence has improved, and you are finding all the problem. And I had said very clearly that it is a perfect case where Mr. Mistry should be sued now, either for dereliction of duty or for causing unfair thing. When I say that Tata Steel is sitting on a 20 billion or 25 billion or 5 billion of a potential loss, then either I am guilty of signing the wrong balance sheet or I am guilty of creating a scare in the market. Both are problem under the security law. So if I escape one door, I am trapped in another door.
Okay. There are some questions, Suhas. Can I take? There are 5-6 questions.
Sure. Please, Arun, go ahead.
The first one is from Mr. Ranganathan. V. Ranganathan, can the panelists comment on the approach of the independent directors in the controversy? These directors who had appreciated the role of Cyrus Mistry in managing the respective companies suddenly seem to have joined in voting Mr. Mistry out.
You see, there is I don't see a direct discussion on the independent director's role there, but there is a discussion about the performance appraisal conducted prior to October 2016. That is, March 2016. And there is a discussion about it to say that while the performance appraisal may have been conducted well, but the fact still remains that from June onwards, there were problems, and therefore that can't go to help and aid Mr. Cyrus Mistry in his case. Similarly, I am presuming that the argument relating to independent directors has been, you see, independent directors as such have a role to play, which is based on the information that they're getting from the operating company and the companies in which they are directors. If the information that they receive kind of, improves their position or forces them to change their stand, I think that's a different matter altogether. And it would be then fully justified based on the kind of information that one receives. So from that perspective, I think independent directors with, information asymmetry in against them, not in favor of them, but against them, could get into an initial decision which could be wrong, could get into subsequent decision which could be wrong, but you cannot attribute to them the kind of chameleon concept or say that therefore they are changing their colors and therefore they are bad independent directors. So that's while there is an implicit discussion in the Supreme Court judgment about the performance appraisal done by the NRC, and I think, yes, in that context, the role of NRC, there was an opportunity for Supreme Court to look at and reassess LIC versus Escort.
This is from G. Shivshankar. He's a third year law student. We have affinity for students, so we will take your questions. According to you all, who controls the company? The majority shareholder or its board of directors? If there is a conflict between the two, who calls the shot?
Should I answer?
Yeah,
Sir,
sure.
please, please.
The corporate structure has 3 tiers. At the top, there is a shareholder. In the middle, there is a board. At the bottom is a management. So this 3-tier structure operates. The shareholder are the real owners. The board has a policy. The shareholder direct the policy. Based on that policy, management acts. Now, whenever there is a problem, ultimately the supremacy of the shareholder will prevail. Now, in order for supremacy of the shareholder to prevail, not to the detriment of the minority, there are laws. So if a board has failed or whatever has happened, the shareholder decides, and the majority shareholder takes a decision which is apparently and in real detriment to the minority, then probably the law will come into the play. Say, for example, if 82% shareholder would have decided that because Cyrus Mistry is 18% holder and I am 82% holder, I am removing that, probably that would have been wrong. But here removal was not because it was 18%, it was because of various reasons. Then on the last question which Suhas answered, I will have to one thing, that you cannot say that a decision or a observation that I have made in June will be good for all the time, because in June whatever information I had decided on that basis. And I would say that even I would have been speaking for Mr. Cyrus Mistry had the conduct of Cyrus Mistry not been exposed in the later events. On 26th of October, when this happened, I was saying that it is removal is wrong because it should not be done in this way. But subsequent event turned me into a different analyst, for the simple reason by email and all other action, he demonstrated that he was not working for the interest of the group. There was something which none of us know what was that reason.
Yeah, we have one more question. What is are the plausible legal remedies available to Mr. Mistry? Suhas sir?
This is at least in so far as the first para of the judgment, which talks about the list in the matter, which is the dispute in the matter. This is the final word. Of course, people will talk about review, people will talk about curative petition, but we all know what happens there in the review and the curative petition. On the face of the judgment and the order, if there are any errors, of course, review is possible. Doesn't seem to be so in this case, though we don't know all the facts. I must say that. But I think insofar as that list or the dispute which is adjudicated in this entire matter is concerned, this is the final word. I don't think there's any room open for any further remedy to be availed.
Yeah, and there is one comment, very interesting. I did observe this. Why does the Supreme Court of late issue orders without specific judge who wrote the judgment being named? I don't know why, but yeah, anyone who studies the judgments of the Supreme Court closely, or even the High Courts where some of the judges have come from, would know who has authored this judgment.
That's only guesswork. I don't think it's a good practice to do that, but I'm sure Mohan sir would want to comment on that.
I do not want to comment, but I know who it is.
No, I think comment on the practice that they don't write who wrote it.
No, it's not a good thing to do, because I think all the judges have discussed, and Chief Justice is the master of the rolls, I say. And
So
you can't, I think Chief Justice is also equally an eminent judge.
Of course.
Justice Bopanna is also a very eminent judge. I don't want to comment more about it. Now you would have actually guessed the answer.
Yes, sir. Thank you very much. You see, what happens is, as a practice, unless there is a dissenting judgment written by somebody, all of them are concurring. I think nobody would say that who has written and drafted it,
Yes.
because it's a unanimous decision of all, in this case, 3 judges. Arun, we can go ahead. Take another.
Absolutely. Yeah, I think finally, Suhas, the way you distilled this analysis is perfect. Corporate governance versus corporate democracy is what this case was pitched as, and it was pitched very high on both sides, saying that one side kept on saying that the New Companies Act pertains to, is all about corporate governance. It's not like the old Companies Act 1956. And now, after Satyam, after many corporate governance failures, frauds, promoters money, corporate governance now has come into eminence. It now has its own distinctive role or place in the hierarchy of company management, of company law, governance, and overall regulatory mechanism. What the Supreme Court has said, that is essentially gone with the arguments of Mr. Mohan sir and others, that corporate governance cannot obliterate corporate democracy, which is what I think the words the NCLT had used, if I recollect correctly. Essentially, the Supreme Court judgment has come. I don't think they're anywhere saying that okay, you eschew corporate governance, but I think they're very clear that it cannot be at the altar of corporate democracy. I mean, you have to, I think, and this is very fact specific, Suhas. This will keep, we will have cases churn out, where the pendulum will swing on the other side. While this is path breaking, I'm fully with Mohan sir. I still do believe that so many of these things are fact specific. In this case, I think what really hurt Mr. Mistry was his conduct afterwards. And I'm fully with Mr. Gupta. And I think that has really weighed heavily on the minds of the Supreme Court judges, plus the history of the Tata Group. The fact that they had never used that affirmative vote before, the fact that they've never used Article 75 before. These are all, maybe you may say, how is it important to this case? But the conduct, the past conduct also came into being here. Gupta ji, you want to say something?
The main thing was his allegation that Mr. R.N. Tata made a personal profit in selling a flat.
Yeah.
It was such a ridiculous,
Yeah.
Selling a flat, few lakhs of rupees,
Yeah.
For the stature of Mr. R.N. Tata to actually make a few lakhs of rupees, like a miserable politician, and making that sort of allegation, I think that will make anybody furious, I say.
Yeah,
So
perfect.
that demonstrates, sir, to me, that demonstrates the desperation of finding something.
Yeah.
Yeah.
That's that desperation there.
And also actually making allegation that he was hand in glove with the terrorists,
That's true. It's
Yeah.
laughable, I think.
Yeah. Gupta ji?
Yeah.
Arun, I want to say that it will be very wrong to look at corporate democracy and corporate governance as two different set of law. It is very important that the corporate democracy has to operate with the corporate governance in mind. The two cannot be divorced. It is very simple that both have to move same. It cannot be at the exclusion of one that you are doing with them. The second thing is this, that I was just reading, the Mr. Mistry has come out with a statement that personally very disappointed with the SC order, and it is an anti-minority, something like this. Again, I am saying removal of Mistry was nothing to do with minority or majority. It was Cyrus Mistry, individual executive director, was removed because of various reasons which we know now, not before.
Yeah. Suhas?
Sir, yeah, see, Arun, one other thing is where I'm seeing it ought to be now reflected as a consequence of this judgment, is this proposition that corporate governance is not a topic to be discussed in a 5-star conferences. It ought to now come to the board level. It is not a consultant's issue. It cannot be fantasized, as the Supreme Court says. And therefore, in my view, I think the best consequence for corporate India would be to move the discussion on the corporate governance from 5 stars to the boardrooms, and make sure that the board and the decision making at the board is actually correctly appreciated.
Demonstrate.
Yeah, we have 30 seconds each. Final comments from Gupta ji, and then last word to Mohan sir. Gupta ji, 30 seconds.
Yeah, I would say that Subhash is bang on when we say that the corporate governance cannot be the topic of seminars or five-star hotel alone. It has to be imbibed. In nutshell, corporate governance is nothing. It is only ethical standard. And if you follow ethical standard, you don't need to read any law. If you read the Supreme Court judgment, it has nothing. It is only the logical analysis of what happened and what should be there. And if the ethical standards are there, we talk about independent director. There is a notion that the opposition or dissent is the independent. No, independence is application of mind to an issue independent of anything, your past conduct, your relationship, your money, or something. And the day we learn, or everybody learns, that ethical standard or ethical conduct is corporate governance, probably there will be no problem.
Mohan sir, final word.
Yeah, corporate governance is like chastity of a woman or a man, I say. You can't say, yeah, I'm chaste, I'm a very chaste woman. No? That can't be boasted. See, therefore, it is actually inherent. No? So every company has to have some ethical standards. There has to be inherent, and you have to prove by your actions. You know? And it should not be, as I said, it should not be part of public discussions. It should be clearly a boardroom action.
Perfect. Suhas, you want to say, propose vote of thanks to everyone. We've had a wonderful webinar. Amazing analysis by Suhas. Gupta ji's incisive comments on corporate governance and the judgment. And of course, Mohan sir's keynote, he touched upon all the key aspects of the judgment, and with all his sharpness, he decoded the landmark ruling for us. Thanks so much for the time. Suhas, over to you.
No, thank you very much, everybody. Thanks a lot, Mohan sir. I think it is always a pleasure to be listening to you. And I think we have heard your arguments in the court and we've heard your discourses, sir. Thank you very mumuch. Thanks a lot, Gupta ji and Gupta sir. I think thanks for, accepting my request to come and speak here. It's been fantastic. And I know we talked about this topic way back in 2016, 17. And this was an opportunity where I think we could speak again. Thanks a lot for that. Thank you very much, Arun. I think it was great for us to do this. We could have done it on Saturday, but because the Holi came in, we're doing it on Tuesday.
There are some 10-15 messages right now in the chat box saying that this was a great session, and people thanking all the panelists. So on behalf of all of us here and Taxi and the Legasis team, thanks to everyone. Yes, Gupta ji.
I want
Thank
to
you.
say that for the purpose of history, anybody who is participating here want to read SES report from 2016 onwards on this issue, and then they can compare what happened and what is in the judgment. So it will be an excellent reading material for those who are interested can write to me and I will send the report.
Sure. Wonderful, sir.
Great, sir. Great.
Yeah. Thanks, everyone. Thanks, everyone, for a patient hearing. And we appreciate you taking out time to listen to our ensemble panel. Thanks, Mohan, sir. Thanks, Gupta ji. Thanks to my dear friend.
One
All
other
the
thing.
best to you. God bless all of you.
Thank you
very much,
everybody.
sir.
Thank
We
you
need
so
all the
much.
blessings.
And thank you, Mr. Parasran and Arun. All the very best to you. God bless you.
Thanks.
Thank you, sir.
sir.
We've not addressed all the questions, but offline we will take them between Arun and me, and we'll address and reach out to each one of those questionnaires.
Sure.
Thank you. Bye-bye. We'll